Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Elyse Dorsey, and the title of today's episode is Axin, the FTC's Administrative Authority, the Implications of Axon Enterprise versus FTC. On April 14, 2023, the U.S. Supreme Court issued its opinion in Axon Enterprise versus the Federal Trade Commission, along with the Securities and Exchange Commission versus Cochrane. This pair of cases raised critical challenges to the constitutionality of the FTC's and SEC's administrative authorities, and the outcomes were eagerly anticipated. The Supreme Court's unanimous decision deferred for another day the underlying questions of constitutionality, but importantly, the court held the parties challenging the constitutionality of such administrative proceedings need not wade through the entire administrative process before raising such challenges. Rather, parties may commence immediate collateral challenges in federal court, which might encourage parties to do just that. In this episode, we'll speak with our guest about the Supreme Court's recent decision and what it means for the FTC and for parties facing the prospect of FTC administrative enforcement. Co-hosting with me today is Jana Seidl. Hey, Jana.
Hi, Elyse.
Who's our guest today?
So our guest is Nandu Machiraju. He's a partner in Baker McKenzie's North America Antitrust and Competition Practice Group and is a true FTC expert. He has significant experience both at and before the FTC. During Nandu's time at the FTC, he served in several capacities, including as an attorney in the Bureau of Competition's Litigation Group, where he played critical roles on merger litigation challenges, and then as an attorney advisor to then FTC Chairman Joe Simons, and as an attorney in the Mergers One division. Welcome, Nandu.
That's great to be here, Jana and Elyse. Thanks so much for having me.
Yeah, thanks for joining us. We appreciate you sharing your insights today on this really interesting development. So we'll dive right in. We know that the decision has been several years in the making, and I think what would be helpful for our listeners if we kind of rewind and talk first about how this case, which was a challenge to a consummated merger, right, first came to be on the FTC's docket. So you were in Chairman Simons' office at the time when this matter first came up. Is that right?
Yep, that's right. I was an attorney advisor for Chairman Simons.
And if you could talk us kind of through the facts at issue and what really were the FTC's concerns about this deal.
Yeah, no, this is a really interesting case, and as you noted, it's a consummated merger. These are the most interesting ones to come through the agencies because, as you all well know, most mergers get filed with the FTC and the DOJ. Parties put in their HSR filings and everyone gets notice of what's going on. But what we have here, we have a merger, there's two parties involved. There's Axon, which is more famously known for its tasers. That's one of their major product lines. And then you have Safariland, which owned the VView business. And both Axon and Safariland with the VView business, they made these body cam systems, and that includes the actual camera that was kind of mounted on police officers and the sort of digital management system that collected all the video and audio files and stored them and had it in a way that, if it needed to be used as evidence and preserve the chain of custody, it kind of handled all of those kinds of things, for the police department. So, when you look at it, this merger took place, I think, on May 3rd, 2018. And as a part of the deal, Safariland sold the VView business. They agreed to a 10-year non-compete, so they were not going to compete with Axon for 10 years. And there was a side deal to provide holsters for Axon's tasers. So a few different things going on in the deal. The FTC investigated this deal, and in January 3rd, 2020, they filed a complaint. And, kind of at the core, if you look at it, if you look at the complaint, there's just a whole host of stuff that the FTC had alleged based on whether they're public statements and documents, things like that are a bit head turning if you think about it. There's indications from Axon where they say that VIEVU is their number 2 competitor in the market. VIEVU said that they were the number 2 competitor in the market. When you looked beyond VIEVU, it was sort of a long tail of other competitors. VIEVU's parents, Safariland, basically said it's really hard to get into this market. So you've got number 1 and number 2, and very hard for anyone else to kind of get in there and compete in this market. You have statements about how there's price wars going on between Axon and VIEVU, which from an antitrust enforcers, when you put on your litigation hat, you've got these emails or documents that say there's price wars between companies and that they're number 1 and 2 and they're about to merge. That's the good stuff. That's the stuff that you're going to use at trial, and it's really, really helpful if you're going to try and bring a case. And so you had a lot of those documents, and then you had this. I mean, what was really noteworthy in the complaint was they called out this RFP with the New York police department, where VIEVU had kind of said they started a price war to get this. Axon responded by offering 1,000 free body worn cameras. So you have all this stuff, lots of evidence in the complaint. Again, we don't know how this would have shook out at trial. Maybe there have been some countervailing points from the parties to rebut that evidence, but there was some hot information in the complaint that suggested that there was some real deep competition going on between these 2 companies. Now, obviously, VIEVU had been acquired, and it had been a couple of years, probably integrated at that point. And so you look at it, and then with this consummated merger, and you kind of ask, well, what are you going to do with this now that this deal is kind of in the depths of Axon now? How do you restore competition in this world to bring back this player that's already been integrated? And that's something that we'd have to see as this trial unfolded, and as the courts or whoever it was really contemplated what relief might have been appropriate. That would have been the next thing that we would have to see.
And I think that's a good kind of transition, when you're thinking about what do we do after the fact. As you mentioned kind of at the start, the FTC is mostly looking at mergers that haven't yet been consummated. This one already had, and then it was brought to the FTC's attention. And like you said, I think pretty quickly gained some traction within the commission. And so when the FTC was thinking about what to do, how, to initially get started on trying to remedy these issues they were seeing, how did they decide to go into Part 3 litigation rather than federal court? And, is that the normal kind of route for consummated deals?
Yeah, it's a great question, Elyse. And it's always really interesting when you read FTC merger litigation, kind of the briefs that come out. One, if you read the district court briefs when they do proceed to district court, and then you'll see a concurrent Part 3 brief, because when you read the district court brief, it always says, we want a preliminary injunction, not a permanent injunction. We want a preliminary injunction, or sometimes it's a temporary restraining order if that's required, if the parties don't stipulate to temporarily restrain the deal pending a preliminary injunction. And what these briefs always say is that we want to preserve the status quo so that we can have the trial on the merits in the administrative process in Part 3. Now, in reality, that doesn't always work. And, candidly, a lot of parties, they always say, we're just going to litigate in district court, win or lose. That's where we're going to be. And we don't want to go through this whole Part 3 process. And so you just end up seeing a litigation in district court. But here, because this is a consummated deal, there really isn't anything to preliminarily enjoin. There's no, typically when the FTC goes to district court, they say there will be imminent harm if you don't preserve the status quo, if you don't prevent these 2 companies from merging. Eggs will be scrambled. Can't unwind this thing if that all happens. So you got to give us the preliminary injunction so we can have the real trial in the Part 3 process. Eggs were already scrambled. This whole thing was already integrated. So it's hard to go to a district court and say, let's get a preliminary injunction. And that's why the FTC has tended to go go through the administrative process just full bore, without really, without going to the district court. There's always the option for the FTC to go seek a permanent injunction. That's available under 13B. But that's never just been the strategy, and it's partly a function of the structure of the FTC. The FTC's trial on the merits is the Part 3 process, and it's, you're supposed to go through this Part 3 process with the commission making a vote, an administrative law judge presiding over the case, then the commission looking at it again, and then going to a federal circuit court where they'll kind of assess if the FTC's opinion meets the substantial evidence standard.
I'm glad you brought up the kind of structure of the FTC and how this process works, because it leads in perfectly the whole reason why we're here talking about this case, right? It seems like then Axon raised issues of the constitutionality of the FTC's Part 3 process to begin with, and we understand that there were a couple of bases for the challenges, right? So first of all, the FTC's clearance process for divvying up merger investigations with the DOJ Antitrust Division, and that so-called dual layer protection of the administrative law judge. And then third, the issue of combining kind of the prosecutorial, the adjudicative, and then the appellate functions within the commission itself. Can you talk a bit more about when Axon first raised those issues and kind of what those challenges kind of alleged a little bit more?
Yeah, of course. It's if my memory serves me, I think the Axon filed a district court complaint in Arizona, before the FTC complaint came out. So they had declaratory relief right off the bat. They're just this is no good.
They were all over it.
Foul on the plate. We're not going to,
Yeah.
And so it was it came first, right? And so they did that right away before the FTC's action sort of commenced. And then the FTC filed their complaint. About a week later, I think Axon filed a motion to stay the proceedings with the commission, and then the commission ultimately denied that stay. And so the different kind of things that Axon had latched onto, and Jana, as you well noted, there's the fact that the FTC, it's this interesting process where you've got a horizontal and vertical separation of powers at the FTC. You've got 5 commissioners who separate that sort of ultimate decision-making power among 5 commissioners to take a vote, and then you vertically separate, where an ALJ presides over the case, commission files the complaint, you votes out a complaint. You've got bureaus who make recommendations and things like that, but it's all within the FTC. It's all paid under the same, allocation by Congress. The paycheck is coming from under the same name of the Federal Trade Commission. And so when you really look at it, it does sort of look like, wait a minute, I'm if I'm a party, I'm appearing from the same group of people this entire way through, and I could be, even though I'm going to trial and I'm appearing before an appellate body, it's still the same. They've still got the FTC on their business card, right? So what is going on here? So you've got a bit of that issue. The dual protections issue. I mean, this is something that's been pinging around administrative processes for a long time, and it started maybe I think about 10 years ago, where you had these questions of, well, wait a minute, you have one part of the administrative agency who reviews another part of the administrative agency, and both layers cannot be removed except for cause removal, which means the president doesn't get to really supervise any of this stuff. It's just sort of, they all are independent. They all, are insulated from political control or political supervision. And so you have this other thing where everyone's a bit insulated from presidential control, and that kind of is a bit strange when you think about the prosecutorial process and whether you have political leadership exercising a supervision over this. They also just kind of pointed out, which is empirically true, that the results tend to be a little one-sided. If you look at it, if you look at the way these cases get litigated, It gets filed by the 5-member commission, goes to the administrative law judge, and actually it can be a bit of a toss-up there. Sometimes you win, sometimes you lose at the administrative law judge level. But it's a bit fanciful to think that once it gets back to the same commissioners who said, we think there could be a violation, that on the back end, they're going to change their mind and say, nope, no longer a violation. And so that raises this other question as to, well, is that appropriate? Why, is that structure reasonable? Really, the issue there is that if Axon was at the Department of Justice, it would go to district court. That's their process. But if you're in the FTC, you have to go through this FTC process. And there's a question of whether that's fair, whether that's, you're getting, treated equally, but given which agency you're going to. And so that's sort of another question that they raised. And so all of those things kind of are at play. And then they also just pointed out this could be a waste of resources for them to have to go through this. This process through the administrative litigation, when in the back end, and then also, go through this challenge in the district court in the Article 3 process. Might as well just do this all in the Article 3 process, which is where they filed their complaint in the first place. So those were some of the big issues that they're raising. That again, the FTC had considered all these and ultimately decided not to grant the stay to stay the proceedings.
Yeah, right. Perhaps not surprisingly, they think their own process is, an acceptable one. And I think, that's one of the really interesting things I found when I first moved to the FTC was, how that wall goes up once you're in Part 3. So I was, also in a commissioner's office. So we'd be able to talk to staff one day. And then, as soon as we voted out the complaints and it was filed, we couldn't talk to them anymore, which is, one of the important ways the FTC tries to preserve and, protect some of these issues. What was the FTC's response overall to these kind of constitutional challenges? Obviously, they denied the stay, but kind of what's their, reaction?
Yeah, it's a great question, Elyse, because I remember when we were both there at the same time, we were in corresponding offices, and it's really tough because what you see at the time is there are a lot of challenges at the Supreme Court, and a lot of these are SEC cases. But when you looked at the SEC, you could draw a very clean parallel to the FTC process. And the commission, I think, in each instance when the Supreme Court, came out with a new decision, tried to respond by kind of taking that new guidance and incorporating it into the agency's process. But I think there's just a bit of reluctance too to read the tea leaves and sort of say, what's the end of the rainbow here? Where is this all going? A district court judge may be much more willing to say, I think we kind of know where the Supreme Court is headed and maybe predict what might be happening next. I think the commission will answer the Supreme Court's kind of assessment and just that and just stop there and so say, look, we've come up with a fix that addresses the free enterprise problem, the looship problem, the Seidl law problem, and then they'll just kind of stop right there. And when you look at
that's a lot of problems you just listed. It's a lot they're trying to deal with, right?
It is a lot of problems, right? And it kind of leaves you. It sort of is one of those things where, as you're kind of going through it, you're wondering, well, we've got our next fix. Is this what where is this going to go? What do we do next? And is this all? Are we all just going to get shut down at some point down the road? Who knows? Who knows what's going to happen? But when you look at when you consider the FTC's approach, they said, look at the cases that are out now. Look at how the courts have addressed this issue. We can put up 7 cases or something like that of how the courts have basically said, look, you don't just because somebody wants to go to federal district court instead of the commission process or the agency process, it doesn't mean you just get to. Congress created this whole process for us, and we're going to follow it. That's what we know. That's what we're supposed to do. And that's what Congress laid out. And by the way, courts have been saying that that's the right way to do this for years and years and years. We can, and if you look at the commission's decision, there are several cases that they kind of can point to where the courts have said that's exactly what the commission's supposed to do. And so, even if Axon had come up with a new and thought in different variation of the theories that had been presented in previous cases, probably the most reasonable thing the commission could do at the time was say, based on what we know, what we've seen, we're going to stick to it, and we're going to say you have to continue to go through our process. And this collateral thing going on with district court is just, it's a different, it doesn't belong there, it belongs here. You can get your ultimate federal court review when this goes to an appellate court a couple years from now. So...
Yeah. And, I think you already mentioned it previously, but there is a question about, how meaningful that appellate review is because of the standard that gets applied in terms of the fact finding back at the FTC, right? But it seems like, Axon persisted, appealed it up to the Ninth Circuit. The Ninth Circuit ultimately ended up siding with the district court's decision, affirmed that. But I think it's notable that the Ninth Circuit did hone in on the FTC's virtually undefeated record over the past 25 years and kind of, stated that it raises the legitimate questions about whether the FTC has stacked the deck in its favor in the administrative proceedings. And so Axon, made the rather unusual choice to pursue that constitutional challenge all the way to the Supreme Court. And Justice Kagan writes that the constitutional challenges to the FTC's administrative authority were fundamental, even existential, right? But the court ultimately limited its holding here. Can you talk to us about what the court actually decided in this matter and what it is that we're looking at now?
And I guess this really goes to show that the way Axon had pled the injury here mattered. That's what ultimately distinguished it. They probably did read all those 5, 6, 7 cases that went the other way and thought of a narrower path that really spoke to what the court could could glom onto. And then, so the court basically said what Axon's saying is that the process that they're being exposed to here at the FTC, in Cochrane too, with the SEC, is an unconstitutional process. And so the question is, well, if this was just something where, you don't like the process, that's one thing. But if you're being exposed to an unconstitutional process, that's a here and now injury. And you should not have to go through a here and now injury in this sort of federal administrative process. You should have the opportunity to have that question answered before you get exposed to just a very long litigation process that will ultimately kind of send you up to the appellate courts. And that is the narrow holding of this case, is that these questions undoubtedly can be answered by the federal district court. And really the Justice Kagan worked through what we call the Thunder Basin factors, which are, a 3-part test where they said, look, would this, would precluding district court review, would that foreclose meaningful review? That's factor 1. 2 is the claim wholly collateral to the statute's review provisions. And 3 is a claim outside the agency's expertise. And, 2 and 3 are kind of the easy ones in a way in this case, which is that, look, this claim about whether the FTC is constitutional or not, whether the process is constitutional or not, the FTC or any administrative agency doesn't have any unique claim to decide its own constitutionality. That's something that a district court is well situated to kind of figure out. That's kind of their wheelhouse. And also, is this something that the agency has expertise on? I had worked at the FTC for 7 years. I'm not sure that we had, over the course of our fact-finding and diligent work on cases, really had an opportunity to develop facts around whether we're constitutional or not. That's not the business of the commission. It's about antitrust or consumer protection, whatever you're doing. That's something that a district court, though, is well situated to kind of think through. So, and those 2 factors, those seem clearly to side with Axon. And then on the first factor about precluding district court review, would that foreclose meaningful judicial review? The court was about, 50-50 on that. But ultimately the court said, look, this is a here and now injury, and it would preclude meaningful judicial review, given that this Axon is going to suffer for however many months, years, whatever it's going to be, under an unconstitutional process.
I think one of the most interesting things about this case is that it is a pretty strong decision, right? There's no dissenting views. The Supreme Court, unanimously decided, to your point, that this was a here and now injury. And I think now we get to the most fun part of our discussion. We've kind of been doing all the build-up work up until now, and kind of get to do a little bit of speculation and, maybe some tea leaf reading. So, I think one of the biggest questions we have is, in the post-Axon world, do you think we're going to see more of these collateral challenges to the FTC's authority? At the time of this recording, I think we've seen at least one, right, in the ICE Black Knight merger matter. So do you think we're going to, kind of be seeing more of that?
Yes, I think certainly to the extent the agency pursues these matters through the administrative process and makes that the venue that they choose. I think you're going to see these collateral reviews from collateral attacks and an effort to bring these matters back to an Article 3 court. As you know, in ICE Black Knight, that was they filed a complaint. They raised these issues with the federal court, and I think you're just going to see more of it and more of it. I think no matter what, even if the federal district court is the main kind of show and everyone decides that that's where the litigation is going to be, it just seems that that's ultimately going to be a defense in one of these cases anyway. I think they're going to respond with that, so I expect we're going to see that a lot more.
Yeah, and so we've talked about how parties before the FTC or the SEC, one of these agencies, might behave in the wake of this decision, but want to flip to the FTC. So we talked a bit earlier about how non-consummated mergers typically go to federal court in the first instance, right, to get that preliminary injunction. But do you think the Axon decision will impact how the FTC thinks about where to file those other matters, like consummated mergers, like in Axon, conduct violations or rule violations that typically would go forward under Part 3 as what we've seen today?
Yeah, it's interesting because it's what you've seen is some decisions that probably have flipped back and forth the decision as to where to go. Right? You bring up, Jana, the conduct violations. Typically, a good reason to go to federal court for conduct violations is because you might be able to get money from it, equitable monetary relief. The Supreme Court said, no, you can't. The FTC, you're done with that game. Close that up. Unless Congress decides to do something different, that's over. So that kind of flipped the presumption in a way, probably back to pursuing things in the administrative process. Now you've got all these challenges, and that kind of raises the question: should we beat back? And should we just do this in district court? Do we want to waste our time kind of fighting these other issues? I think with the most interesting cases are going to be the consummated mergers, or the mergers where the parties cannot close the deal because there's some other thing holding it apart. Very often you have foreign agencies, who are reviewing the transaction and who have authority to keep the deal apart. And because of that, this deal, can't close. And so it makes sense to go through the Part 3 process. Now you've got this question of, well, does it make sense to go to the Part 3 process, or should we go just seek a permanent injunction and go through that? And I think there's definitely going to be a stronger incentive going forward to just do that, to just get a permanent injunction. I will say that, as one of the logic of going through the Part 3 process is that sometimes the commission wants to bring an interesting, new, different theory. They want to try something that reflects their own expertise or views on the law and how to develop it. And the agency process provides a nice venue to do that, because you get to write a fully reasoned decision at the very end of this whole process that spells out, what the logic is. And as the commission has tried to develop presumptively unlawful or quick look kind of categories, that's kind of been the manner in which you do it. You use the economic evidence that they can interpret, you use all the things that the commission knows how to do, and you put them in a decision, see if a court buys it, right? And that's presumably where you might see more of this action continuing through the administrative process. But I think certainly for cases that seem a little bit more vanilla or just more easy, having fewer kind of complex issues, it would seem like maybe just seeking the permanent injunction would just be the cleaner process to go.
I think one of the things you just said brings back something from a bit earlier in the conversation where we were talking about, the different processes between DOJ and FTC. And, we do live in a, kind of global enforcement world today. And if there's other jurisdictions that are holding up the merger, as you said today, the FTC can choose to go into Part 3. That's not a choice the DOJ has, right? So I think, again, it's something that's highlighting the differences between the two agencies in a way that could prove problematic for the FTC down the road. Again, in Axon, the Supreme Court just kind of deferred all of the questions of constitutionality for other cases and other days. But I think it definitely is something that's on parties' radars. You mentioned earlier the FTC's initial inclination was just, okay, like you can allege these issues, during your appeal. And as you mentioned, like sometimes that can take a few years, and allowing the kind of immediate collateral challenges flips that a little bit. So some of that allows for the district court to issue a stay of the FTC's proceedings while it's kind of trying to figure out the constitutionality issues. Do you think that's something that's going to have an impact on the FTC's calculus in where to bring its cases?
Yeah, you can imagine a scenario where the FTC just says, let's proceed with our administrative process. Then I think what you'd imagine the parties would do, they'd seek a stay with the commission. Commission would have to write its decision as to why the stay is denied. Then you go to district court, and then you seek a stay from a district court and say, look, we've already, how many more of these Supreme Court cases do we need to kind of tell us what ultimately we all kind of know, which is that we should have the opportunity to try these cases in federal district court, and I think the incentives are going to ramp up and up and up for a district court to at some point just say, yeah, let's grant the stay. We kind of see where the Supreme Court's going, and let's just let's stay this process here, and let's entertain these questions that have been posed, which the Supreme Court had said this is the right forum to entertain these questions. And oh, by the way, there's a here and now injury, so it would be weird for us to entertain these questions, but allow the here and now injury to continue at the administrative process. So you could see that seems like a fair chance of winning that stay. And then, try the case in district court and see if you prevail on the constitutional questions. So I think that does create that incentive. And then if you're the agency, you just have this question of, well, wait a minute, if we want to actually try our case, are we losing something here? Are we losing time that's valuable to by continuing to proceed through Part 3? Does it make sense to just do this in federal court and get our resolution now? I think that's going to be an important question too, and it's something that the agency will want to think about, especially if there's ongoing harm that they're seeing right now. They may just want to resolve it and not have to ping pong things back between the administrative process and the Part 3 and the district court process.
Yeah, and I think that also kind of feeds in a little bit. We talked about the criticism previously that of the administrative litigation process, the pre-Axon parties that were facing the FTC kind of had few means to challenge that administrative process earlier, like you mentioned, right? They kind of had to go through that entire process, then appeal it up to the circuit court to then be able to actually raise questions afterwards. And so that seem to lead to incentives for parties to, enter into settlements with the FTC to avoid the entire thing, right? Instead of working through these issues like you discussed. So do you think Axon meaningfully affects the negotiating leverage between the FTC and the parties that would otherwise then be subject to the Part 3 enforcement process?
I think in rare situations, it might affect, and in select situations, I would say it might affect the leverage. It's really that narrow classes of cases where the administrative process makes sense and it might make a difference for you. That's where I think the leverage kind of looks different. Otherwise, the FTC attorneys who bring these cases, they're adept at bringing these cases in district court. They do it all the time, and they have, a playbook for how to build the evidence and come into court and get ready to play. So, I think for a lot of cases, I don't think it changes that much. I think it's ultimately the merits of the case is just going to decide whether to settle or not to settle. But there might be some situations. Something I could think of is that it could be that the FTC wants extraordinary relief that just the parties are not going to sign on for, and maybe the only way to get that extraordinary relief is to go through the administrative process, to have the commission write a decision, write the order, and say, here's what our injunctive relief looks like, and it is pretty extraordinary. Or maybe it's not that extraordinary, but it's not really well tethered to the merits of the case, and maybe they're reaching. It's not really fencing in relief in the way we think about it. And those are the kinds of situations where I think if I'm a party, I would just push back on that and say, wait a minute, I don't think you're ever going to get this. And by the way, we now have a cleaner path in district court to press our claims. And so maybe that just narrows the kind of relief that the commission might ultimately seek.
Yeah, well, you've given us a lot to think about today. This has been a really interesting discussion, and I think kind of highlights some of the issues we'll be seeing over the next few years. And I think one thing we can probably say with some amount of certainty is that we'll see, as you said, additional challenges to the FTC's constitutionality in the coming months and years. And for listeners who are interested in some of these issues that we've been talking about today, we actually have another podcast episode that goes into depth on some of the other issues. But for today, Nandu, any kind of final thoughts or anything you want to leave us with?
It is so interesting to see where all these cases are landing and how the court is kind of deciding some of these cases. I think some of them, as we saw them at the incipiency, we thought really the merits of these seem kind of weak and not likely to end up the way they do. And then all of a sudden you get a 9-0 decision from the Supreme Court, which makes you think, well, okay, maybe it wasn't such a weak case or it wasn't such a weak issue. I think having worked at the FTC for a long time, for 7 years, I think the majesty of these kinds of agencies is that they have internally the tools, the personnel to be expert in some ways. You have the ability to study issues. You have the ability to kind of the talent and the staff to really work through hard questions. And you see some areas where they really have been able to break through and bring some thought leadership in a way that's developed the law. I think what we're seeing is a strong pushback on the notion of an expert agency and the very fact that these agencies are expert in some way, and really that model I think is being pared back a bit. I think we're going to see at some point, and maybe the Supreme Court's already taken this up, a case on reconsidering Chevron, right? Whether that is going to continue as it has, or whether agencies will get deference in how they interpret statutes. And overall, I think what we're seeing is that the FTC is probably going to start to be cabined into just a pure enforcement agency as opposed to an independent expert agency that is about studying and developing expertise and using that to develop whatever it might be, whether it's enforcement actions and enforcement actions that inform the law, or whether it's rulemaking and things like that. I think we're just seeing a sense of all of this kind of getting whittled back a bit. So that's who knows what that's going to look like, but we'll see.
Yeah, it'll certainly be interesting to see how this all continues to play out. Thank you so much, Nandu, for the really fascinating discussion and for sharing your expertise with us. But before we let you go, we have a few questions for you to help our audience get to know you personally a bit better. So I'll kick it off with the first one, and that is, what advice do you have for young lawyers?
Yeah, it's an interesting thing because I was thinking about, what did I do as a young lawyer, and was that any good? Was that the right path? And so, I think the thing I would recommend is do as much as you can, get involved. And I remember in my early years, I would get involved with different things, whether it was the ABA, whether it was just the work, and you kind of think that you're too junior for any of this to matter, the interactions you had or the relationships you built. Fast forward 12 years later, some of the people you interacted with as a junior attorney, whether it was, working with them on an ABA project or something like that, are people you're kind of interacting with, still. And I think that's something that, I just commend everyone to kind of just do as much as you can. Do the work, do work with the ABA. Just find every opportunity to get involved with, and just really take in as much of this fascinating bar we have, because it is a small community, and we all kind of get to know each other, and those relationships will stick around for years and years.
Yeah, I think that's great advice. I've also, found that to be true over the years, and, it can be intimidating at the beginning, but there's, I think, a really big payoff in the longer term. So last question for you. Tell us something about yourself that we might not know if we only had met you briefly professionally.
Yeah. This is the typical icebreaker question, right?
That everyone loves.
Everyone loves this question. This is the favorite question that you get to answer in any situation. So let's see. So something interesting. When I was in high school, I played the trombone. I haven't picked it up since high school, but I played the trombone for 4 years, and in my final year of high school, I joined a ska band for 6 months, and so that is my interesting fact. I will represent. I cannot play that instrument for the life of me. I have no idea what any of the positions represent, and certainly do not have the muscle memory to play the trombone again. But that is my interesting fact.
Nice. That is a fun fact.
Yeah, that's a great one. I was going to say, it might come back to you, and then you might be able to play in one of those law firm bands that usually compete once a year.
I will play once, and they'll be like, "You're not going to come." This is no good for anyone.
Yes. Well, we could use you, when we need everyone to leave, we can get you the trombone on the stage.
Closing time.
Yes, absolutely. They're like, no, it's time to go.
Yes. Well, on that note, again, thank you so much, Nandu. This was a really great discussion. Thank you for joining us. Thank everyone for listening, and we hope you tune in next time.
Yeah, thank you so much. It was great to be on here with both of you.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.